now call the case of State of Kansas versus Justin Eugene Thurber, 102-605. And counsel, I believe you're both present here this morning, and you may approach and begin your argument. Thank you.
May it please the court, Caroline Zuschek of the Kansas Capital Appeals and Conflicts Office here on behalf of Mr. Justin Thurber. If I may, I'd like to reserve 3 minutes for rebuttal.
3 minutes will be reserved. Thank you.
Thank you. Would this court care for a brief recitation of the facts?
I don't think we need to do that. We could just go ahead and move into argument, and thank you for asking.
Today, my argument will focus on the district court's gross misapplication of the threshold inquiry and how its failure to view the evidence in the light most favorable to Mr. Thurber prior to the appointment of neutral experts and a full, fair hearing was both illogical and illegal in violation of his constitutional rights. The district court's failure to examine the evidence in the light most favorable to Justin and/or to permit the state to refute his prima facie case of intellectual disability was both illogical and illegal. It was illogical for 5 reasons. It was belied by the statutory language. It was belied by this court's order remanding for a threshold inquiry. It deviates from the procedure used in other Kansas intellectual disability cases. It deviates from Kansas law on all other threshold questions in which the court reviews the evidence in the light most favorable to the party seeking to survive the threshold. It deviates from all other states that have Atkins screening procedures, if there's a procedure at all, and it's practically impossible to apply, which leads into why it was illegal in this case. The district court standard essentially requires an adversarial gauntlet to determine if you get an adversarial hearing, all before the accused has had the chance to be examined to determine if that condition exists.
Before we get into the meat of the law stuff, I want to talk about the procedure. As I reviewed the record, it appeared that kind of right before COVID, February 2020, I think, the court had said, we're going to look at the IQ scores first. And everybody agreed with that, both the prosecution and the defense. And then you all the defendant filed a brief. The state came in and said, whoa, we want to go also into adaptive functioning, right?
Correct.
I also understand that, my look at the law, and I don't correct me if, is that the court can look at the test scores first. And depending upon what those test scores show, the game's over. You wouldn't be able to move into adaptive functioning discussion if your test scores were really high, is what I'm getting at. You've got to be in a margin of error land before you open up the adaptive functioning. So you're grimacing. You tell me what your reservations are about that.
That is not exactly my understanding of Hall and Moore. Both those cases from the United States Supreme Court say once there's a question, then you need to be able to present evidence of adaptive deficits as well. You can't limit it to just a test score, even just to a test score within the margin of error, because as the DSM-5 TR states, and I can give you the page number in a minute, someone can have an IQ of 73 or 75 and still be diagnosed as intellectually disabled with significantly sub-average intellectual functioning and concurrent adaptive deficits, because the adaptive deficits in some cases can be so significant the person functions as if they actually have a lower IQ. And that is part of the diagnostic standards for intellectual disability.
When I read the transcripts of the February 2020 hearing, I understood the defendant's position to be that you would make that showing. I thought I understood the court to say, okay, we'll look at that first. And then you all are saying, if we don't get over that hurdle, if we do get over that hurdle, then we're going to want a year and a half or so to do adaptive functioning discovery and all of that. That sounds to me like the first prong, the test score discussion, could end this issue. Or are you telling us that no matter what happened with those test scores, you were going to be entitled to pursue adaptive functioning evidence and a presentation of that to the court?
No, you're correct that there probably is a point where the scores would be so high that there would be no question that the person was not intellectually disabled, but we're not at that point in this case. First of all, Mr. Thurber did present one IQ score, the 75 from Dr. Barnett, that with the 5-point standard of error would be at a 70, which qualifies. That's a prima facie showing under prong 1 using an IQ score. Now, presumably if the only score he had was like a 95, even with all of the adaptive deficits, there wouldn't be a reason to continue the intellectual disability analysis, because the IQ would be so high as to suggest that the adaptive deficits resulted from something else. There does indeed have to be significantly sub-average intellectual functioning. But first of all, it's irrelevant what this court sets that cutoff at, because we met the 70 in this case with Dr. Barnett's score. And even if this court discounts Dr. Barnett's score like the district court did, the 73 applying the range of error to Dr. Nystrom's test score would still be close enough to the line that a person with a 73 IQ could be diagnosed with an intellectual disability under the DSM-5 TR. So yes, there would be a point at which no adaptive deficit information would likely be relevant, but that's not the situation in this case.
Regardless of that, just as a matter of the way this is structured,
Correct.
it is possible you could have lost at the first prong on the tests. Regardless of what the fact, I mean, it's possible a defendant.
It's possible someone could.
On the first prong, which would have made the adaptive functioning discovery and all that unnecessary.
Correct.
Okay.
I think that is true, because both prongs do have to be met. Similarly, if someone had no adaptive deficits and a 70 IQ, you could potentially lose that way too. Hall and Moore appear to preclude making a decision without looking at everything though. So I hesitate to say that it's always okay to disregard it. But again, I don't think that decision has to be made here, since there was evidence presented in both his motions and at the hearing of both prongs.
Can I ask you to back way up for a second and just ask, what is our standard of review?
Well, I think that's up for debate.
Well,
So-
yeah, you intuit my question. In Thurber, what I'll call Thurber 1, when we remanded, it seemed pretty clear that we articulated an abuse of discretion standard. Would
That
you
is-
agree with that?
Yes, absolutely.
And are you not willing to concede that that is our standard of review? Do you want us to overrule ourselves from Thurber 1?
Yes, ideally, though I think Mr. Thurber wins a new hearing either way. I will say that the abuse of discretion review was reasonably pulled from competency cases and brought into the intellectual disability standard. However, there is a difference between procedural and substantive competency determinations. And the vast number of appeals, in fact, I could only find one published case by this court in the competency realm where the person was outright denied the hearing. Like the majority of our competency decisions in Kansas arise when the accused met the threshold and a hearing was held, and then you're reviewing the actual hearing.
Well, let's assume
For
for
abuse
sake
of
of my
discretion.
question at least, that we do apply an abuse of discretion standard here. How would you articulate the manner in which the district court abused its discretion?
Okay, it abused its discretion by not applying the procedure this court uses in every other threshold determination. It abused its discretion
Would
by,
that be an error of law? I mean, we have three prongs: a mistake of law, a mistake of fact, or no reasonable judge. Which one are you hanging your hat on?
all three. I
Okay,
think that's both a mistake of law, like a misunderstanding of a threshold inquiry that's counter to this court's law on threshold decisions.
can I stop you there and ask you about that? I realize you're hanging your hat on all three, but back to Thurber 1, we said about this exact remand, we emphasize it's not an opportunity to develop post-March 2009 facts in making the threshold reason to believe finding. That will be up to the district court as it considers what the law requires and what facts it needs.
Correct.
So it seems like we just said it's up to the district court to decide how to do this. How can that be, with that language, how can the procedure used be an abuse of discretion?
Well, first, you said it's not necessarily going to require the development of post-2009 evidence, which I think is critical. And you left it up to the court to apply the statute. And the statute itself contemplates a threshold inquiry. It doesn't.
Right, so I'm trying to be precise. How, in your view, did the district court make an error of law in the manner in which it went about the threshold reason to believe finding?
Okay, it misapplied the statutory command, both in language and in spirit, by having a hearing to determine if there would be a
So
hearing.
do you think, I mean, if the district court judge had just said, I'm here, I have to make a threshold reason to believe finding, I've reviewed the entire case file, and I find that the defendant has not met the threshold. I mean, you would be here arguing, whoa, you can't do that. You have to have a hearing. You have to receive evidence, wouldn't you?
Yes, but also that would have violated this court's order on remand. When this court remanded it, they specifically directed this court specifically directed the district court to evaluate the motion, and in light of new modern standards.
Right. So I'm just trying to figure out, given, I mean, I understand your position might be we screwed it up in Thurber 1, but given what we said, I'm struggling with that first prong, that error of law. I mean, what was the district court supposed to do?
The district court was supposed to make a threshold finding. And in Kansas, all other threshold findings are looked at. Does the accused or does the state or does the civil party make a prima facie case of
Okay,
this?
so would it be fair to say that your articulated error of law is that the district court chose to consider the evidence in totality rather than only looking at the showing made by the defendant?
Yes, and if it was allowed to look at all of the evidence before making a determination, then it needed to make the inferences and weigh the evidence in the light most favorable to the party seeking to survive the process.
And did the district court, well, can a fact finder do that? I mean, if a fact finder is weighing evidence, is there any other context where a fact finder weighs evidence and yet is supposed to put a thumb on the scale on one side or the other?
Oh, absolutely. But that's after a full and fair hearing and full process. For example, a bench trial, obviously the fact finder would be weighing evidence. But if we're talking about threshold determinations, for example, even like the review of the summary denial of a habeas petition, the transitional release hearing for a sexually violent predator, a preliminary hearing where the state wants to take the case to trial, a civil motion for summary judgment. All of these are threshold determinations with similar language to
But
the one.
don't all of those include within them something along the lines of it's almost like a motion to dismiss. Summary judgment, there are no uncontested facts. The preliminary hearing, the defense doesn't present evidence. So
Right.
you're just weighing the evidence presented by one side against the legal standard. You're not really in the role of a fact finder, are you?
Right. And that's what should have happened here.
Right. So that gets to what I'm saying is your argument is that district court erred by permitting the state to present evidence effectively. That the court was supposed to just look at the evidence presented by the defendant and then make the threshold determination.
Yes.
And then it could proceed to a full-blown hearing.
Absolutely. So,
And my last question, sorry. What is the legal basis for that claim?
well, first of all, the statute says this motion can be brought by the warden, the sheriff, or defense counsel. So how could a sheriff or warden ever get past that threshold if what was required was more than 23 witnesses and 5 experts? Like that would render, if we were to say that this always starts as a contested hearing where you have to have affirmative proof of a diagnosis of intellectual disability before you've ever had need of that diagnosis. If that is the standard, then that clause becomes superfluous. Moreover, moving on in the statute, it says, after the determination is made, you appoint 2 neutral examiners. After you meet the threshold, you appoint 2 neutral examiners. And then it provides the procedure due in that hearing, that you get a chance to cross-examine witnesses and the right to confront the experts. And these things are valid and important because they're grounded in the United States Supreme Court's jurisprudence, in Ford v. Wainwright, in Pate, in many cases in which they've discussed, first of all, the unique risk of the intellectually disabled of being wrongfully executed. And secondly, that the Eighth Amendment proscribes the execution, but in doing so, and in Atkins and in Ford, the court left to the states the duty to develop procedures to safeguard that right. And Kansas did that when the Kansas legislature did that in the statute. They say this threshold inquiry is meant to be a speed bump, not a roadblock. It's meant to stop anyone who has no legitimate claim from wasting the expense and time of the state. It is not meant to stop people who have debatable claims. And is there evidence that supports a finding that Mr. Thurber may not have an intellectual disability in the record? Yes, obviously the district court relied on facts and the state's witnesses testified to that. But at the threshold stage, before he's had an opportunity to be diagnosed, it can't be that he has to come up with a formal diagnosis. If he had a formal diagnosis, then we would never have needed the hearing in the first place. We could have just handed it over to the state and the death penalty would have been presumably gone unless they contested it. The whole point of this hearing is to allow people who haven't previously had access to these resources for socioeconomic reasons or other reasons to get a chance to a fair determination of their intellect before we execute them.
State versus Corbin, which came down in 2016, about 2 years before the Thurber 1 decision.
Yes.
I think expressly said that this threshold determination is made without a hearing. That's expressly said there. How did the district court get to a place where it had a hearing when there's at least one decision of this court that says you do this without a hearing?
I think that's a great question. And I think that's another example of an error of law. There was direction. And Backus, another intellectual disability case applying the prior version of the standard, said the evidence viewed in the light most favorable to Backus doesn't support a determination that there's sufficient reason to believe he suffers from intellectual disability. So both of these standards had been outlined previously. The court didn't even have to look beyond those cases. And to the extent that it did, it failed to look at other threshold inquiries.
That's not.
I'm sorry.
Okay.
I went digging, just to follow up on, I went digging to see whether anybody raised Corbin to the district court to object to this hearing. I didn't see that. Am I missing something there?
No, I didn't see it either.
And then one final thing. when the state came in and said that it wanted adaptive functioning discovery and all of that, the defendant agreed to it, right?
I'm not
I
clear.
read the transcript.
Oh, I
Your
trust you there.
position was, it seemed to me, that we agreed to go into adaptive functioning discovery and that you took the state's motion to go into it as a concession that you'd already met prong one. So now you had to fight prong two, which is the adaptive functioning discussion that we had earlier.
I think practically
Okay.
that is part of what happened here. So to the extent that prong one became contested at the hearing, there was a lack of notice that it was going to be disputed. You had a question.
Yeah, I don't know if I'm reading Corbin the same way as you are, because at least our review in Corbin, there was some confusion about whether or not this was a threshold question or was this a subsection C sort of evaluation, and the fact that the court had not complied with that procedure, engaging these additional experts, confirmed on review at least that it was a subsection, may have been B procedure, but subject to the same reason to believe standard. And it appears the court just looked for whether or not there was substantial competent evidence that supported the district court's findings. So I understand that you are not proposing that as how we review, but I'm wondering, and that's the same in Maestas and Backus too, it's sort of appearing to do a substantial competent evidence review. I mean, it seems like you're suggesting a framework or a focus that's quite different than all of that precedent. Now, none of those were death cases, so I'm not sure if that plays into it or not.
Yes and yes. So do I think that that framework is sufficient? I think it depends on the evidence presented by the accused and how they argue it. Like, first of all, all of those defendants, as far as I can tell from reading the cases, did not submit 100 pages with exhibits on how they met both prongs. It was just more, frankly, like what happened in the initial phases of this trial, where the defense got up and with very little evidence behind them other than pointing to some questions in the record that he was borderline, asked for the hearing. Had those accused put forth the kind of evidence that we're talking about here, I think how we viewed the evidence and whether the evidence was substantial and competent would have been more relevant questions. But in those cases, first of all, in Corbin, we remanded for a hearing. In Maestas, he got a hearing. And in Backus, we found he wasn't entitled to a hearing, but his evidence on the prong was, I think the quote was like, he didn't even present evidence. His scores didn't even meet the threshold because it was under the old standard. And the evidence was controverted as to whether he'd ever received special education services. I think Backus would have a different outcome under Moore and Hall. I mean, to the extent it applied in a non-capital case. Also, to the extent that I'm requesting a broader procedure, I think the statute makes clear the procedure is the same, regardless of whether you're talking about a capital accused or a non-capital accused. But I don't think we could ignore that heightened reliability inures in a death case. And to quote Justice Marshall from Ford v. Wainwright, why would we have less process now, or to paraphrase him, I suppose, when we're determining a fact antecedent to execution than we would at any other phase in a capital proceeding? And importantly, this case wasn't raised on habeas like a lot of the Atkins claims adjudicated by other courts. Like, this was raised in the proper time. The proper framework couldn't be applied at that time because the law changed subsequent while the case was still pending on direct appeal. But Mr. Thurber preserved this objection at a time when the more favorable standards should apply. And those cases the United States Supreme Court cases do emphasize that there's a procedural due process right to the procedures that we set out in our statutes.
If there aren't any other questions on that part of the case, I want to move you over to the discovery order.
Yes,
I know
absolutely.
you're out of time, but we're not going to pay attention to that right now. I want to hear what you guys have got to say about not only why the district court was wrong in letting the state go through your files, but what the remedy is.
Yeah, absolutely. So the district court in this case ordered the defense, as you all know, to turn over the names and statements of 73 witnesses prior to a decision made by the defense team on whether they would use any of these witnesses, either to call them at the hearing or even to give their interview notes to the experts to rely on. And the timing is kind of problematic as well, because they did it after these 73 interviews had already been conducted, meaning the defense had no ability to choose not to interview people they knew would potentially lead the state to damaging evidence. And then they did it before the rest of the investigation could continue, undermining the defendant's right to have a defense prepared free from interference of the state. First of all, Kansas's discovery rules do not imagine such vast discovery. Under 223212C, which I understand the state says doesn't apply because it's a pretrial hearing statute. Nonetheless, that provides a guideline on what's typically considered reasonable. The materials that the defense has to produce include materials that they're going to admit at any hearing, and a written summary and the names of what any expert witness intends to testify or their report. And the statute very clearly precludes, under subsection D, reports or memoranda or internal defense documents made by the defense or defendant statements or statements made by prospective witnesses to the defendant or his agents or attorneys. So it very clearly excludes this kind of discovery. Now, I'm well aware that agreeing to a discovery order allows the court to enforce reciprocity of discovery. However, to the extent that the parties agreed to discovery, it was agreeing to discovery that would generally be subject to disclosure. And that's why when this order came up, the defense not only objected, I think 5 times at the hearing where it was orally ordered, but objected again in writing, had another motion on it. And then when they finally filed it under seal, did so under objection. And here, evidentiary rulings can abridge the due process rights of an accused to a fair hearing or a fair trial. For example, in the case of United States v. Schaefer, 523 U.S. 303, excluding relevant evidence, which also occurred here, for example, any evidence after 2009, when the reason for doing so is arbitrary or disproportionate to the purposes it is designed to serve. And then quoting Hickman v. Taylor, not even the most liberal of discovery theories can justify unwarranted inquiries into the files and mental impressions of attorneys. Goes on to describe the work product doctrine and the effect on the legal profession of allowing such broad discovery would be demoralizing in the interest of clients poorly served.
Let me ask a quick clarifying question.
Yes.
So when it was filed under seal, was it just the court could look at it, or has the state looked at it?
The state looked at it.
Okay.
Yeah, the state received it. They delivered it to the state. They just didn't want all those witness names for the confidentiality reasons to be publicly viewable.
So getting back to Justice Ball's question, what's the remedy?
Well, there are 2 sorts of camps looking at this, and either would be appropriate. So a number of jurisdictions hold that this error, there is no real remedy. They say once the privilege has been violated, you can't unring the bell, essentially. Like, this is the proverbial bell. Other states have talked about how once this is out there, even an order precluding use of the testimony in a future proceeding doesn't change the knowledge, and that even appointing a special prosecutor who doesn't have that knowledge doesn't take away the risk that the discovery unlawfully compelled led to the discovery of different evidence, like the fruit of the poisonous tree. And those cases basically hold there is no remedy. You can't take back this egregious error. Admittedly, most of the jurisdictions that hold that there is no appropriate remedy have a collateral writ doctrine, even in criminal cases, which Kansas does not. So in those cases, the proceedings would have been stayed. The order compelling the discovery could have been appealed, handled separately in a piecemeal appeal, and then the decision would have been binding on the district court. Kansas does not have that process. Both the state and the defense have previously asked this court to apply the collateral doctrine. It's refused. That was not a remedy available here.
We've done that. Let me interrupt that answer. We've done that though in civil cases when, especially in medical malpractice cases and stuff, and the plaintiff gets an adverse order on discovery and they do an original action. And why wasn't that a potential remedy?
Yeah, so let me find the part of my notes that talks about all of the Kansas cases that hold that a criminal defendant can't avail themselves of that remedy. Basically, there was State versus McGaw. The right of appeal is limited to 223602 because Kansas disfavors piecemeal appeals. And in that case, I think he was appealing an order refusing to seal the preliminary, the probable cause affidavit. And this court said, I'm sorry, we have no jurisdiction over the appeal. And that client argued the collateral writ doctrine. And this court says we've applied that in civil cases, but there's no indication we'd apply it in any criminal matter. And it cited to State v. LaPointe, which refused the state's invitation to consider whether the collateral order doctrine applies in a criminal case, and to State v. Webb, which was a Kansas Court of Appeals opinion, where the district court denied the defendant's motion to dismiss the complaint after his first trial ended in a mistrial. And it found that even the threat of double jeopardy was not a reason to allow collateral writs. And we refused to do so, I quote, because such a course would ignore both the statutory nature of the right to appeal and Kansas case law. So this was not an available remedy here.
Getting away from the, what might have happened, still on what's your remedy
Okay.
request, but part of that I think needs to weave in, how did it hurt you in the end? I mean, I understand the intrusion part, but as a practical matter, how did that affect?
So one remedy, I'll just briefly say the remedies and then I'll explain the prejudice that occurred, because this is typically reviewed for harmless error in the jurisdictions that do look at the remedy. One remedy would be to find that this error cannot be cured and to find that he is entitled to a life sentence because he can never have a fair hearing on his intellectual disability in light of the compelled disclosure. That is the most extreme remedy, and frankly, don't think it's likely that this court will be doing that, but I want to put it out there that that's the only way to truly avoid anything ever being used against him that was compelled to be disclosed in violation of his privileges. Moving on from that, it's possible to, it's called like an order against future use. So remand the case for either, well, for the full evidentiary hearing, because we argue that this court can determine he met the threshold by looking at what was presented at the hearing and his motions. And at that time, preclude use of any testimony gained or any information gained from the disclosure and from calling any of those witnesses, through also appointing a special prosecutor to make sure that they're not aware of that knowledge. And when the state turns its file over to the special prosecutor, to require an in-camera review to make sure they're not turning over anything stemming from that. Those would be three ways to protect the right in a future proceeding. And those are all suggested in courts that do find that there is a remedy for when this happens. To quote, like, I think it's Maryland that says, the remedy is just as the same in any other adversarial proceeding. You remand for a new proceeding and you excise the availability of the testimony.
Okay, so I've got another remedy would be he gets life without parole. Another remedy would be order against future use, in this case, at the step 2 hearing. What was the first one?
The first one was convert to a life sentence and then
So
order.
You had said 3. There are only 2?
Oh, sorry. Well, I guess the third one would be to remand for a new threshold hearing, at which the use was prohibited. And then, of course, the special prosecutor and the in-camera review of the file would be critical as well. Probably even a different judge, to the extent that she could not, or he could not excise the knowledge from those witnesses.
The problem I had, I was thinking through this, and the problem I had with, trying to do a red team, blue team kind of thing, like you might do if you were doing discovery in a lawyer's file, is that you've already had this hearing. State's lawyers have already cross-examined or examined witnesses, and anybody that the state brings in, even if it's, somebody new, that's told not to talk to the other lawyer.
I know, they can read the
They
proceeding.
still got a trial transcript there.
Yeah.
And so any poison that comes from this error is going to be there. But that's why I'm asking, how do you think this kneecapped you?
Okay, well, I will move to talk about the prejudice now. First of all, it chilled the preparation of his defense because once the order went into place, there was a fear of interviewing anyone who might have bias against him, even if they also had helpful information on his intellectual disability, because the state would then be alerted to them to call them to testify. Now, that obviously could be remedied on remand because the same chilling effect would not be in place, but that's nonetheless a prejudice that he suffered, requiring reversal. The second, it resulted in disclosure of witnesses he did not call at trial or proffer for his experts to rely on. So the state got this information, a windfall, I think is how it was described in other cases. It interfered with his investigation.
Before you move on to the next one, and then did the state then rely on any of those witnesses?
Yes.
Okay.
The defense called 17 lay witnesses, 13 of which were disclosed in this order by the state. And the state, this allowed the state to interview them prior to the hearing, potentially to influence their testimony and or bias them against Mr. Thurber, especially in light of the heinous nature of the crime and JS's beloved place within the community. And in fact, like on the record, the defense attorney put in that when they were interviewing people, the police were then going to also conduct interviews and telling them that Justin's counsel was trying to say that he didn't understand right from wrong, and that's why he couldn't be executed. They were muddying the actual determination that was being made and emphasizing the nature of the crime, kind of stirring up the passions about JS, who was undeniably a wonderful person and beloved by everyone. And it's really one of those situations where almost everyone that knew Mr. Thurber also knew the victim and liked her more. The state called 3 witnesses from the list in their case, and potentially found other of their witnesses by talking to the witnesses that were listed in the file, including one of the witnesses they called was particularly damning to Mr. Thurber. Carolyn Osborne's testimony stuck out to me more than any other witness who testified. She's the one who said he liked being called monkey boy, and some kids just like being made fun of, and that he didn't have an intellectual disability. He would have been a fine student if he had just tried. And obviously there's biased motives for these people because they loved JS. They also use the defense interviews to impeach their witnesses. For example, Tracy Beckwith, one of the witnesses called by the defense, that was disclosed on their list. Do you remember being interviewed by defense investigators a couple times? Yes, I do. May I approach, Judge? I'm going to show you what I got from them and have you look at it. And it's not clear to me whether these things were disclosed as part of the invalid discovery order or if they were disclosed as part of some reciprocal discovery observation. But I don't know that even under a reciprocal discovery provision, the actual statements witnesses for the defense made to the defense attorney are discoverable and used to impeach credibility. Anyways, do you recall telling defense investigators he was smart enough to be selective about who he intimidated? I would say that's an accurate statement. And then Tracy Beckwith didn't remember telling defense investigators that Justin had been promoted. And in fact, he was never promoted. And so they used that to suggest that he wasn't being truthful. And that's on record volume 101, page 170. And then again with Miss Kelly, do you recall being interviewed multiple times by defense investigators? During one of those times, you said that Mr. Thurber took a long time to complete his task, but that was just because it was being a teenager. And this was to contrast her testimony that he took slower time than his age-related peers.
Okay, so is it, do we not know whether or not they actually got the attorney's notes? I mean, how do you not know that?
It's not in the record. What was in the record that I read was what was filed under seal was just a summary and the names.
And so a summary of what?
A summary of what each said, but it was like, it's volume 90. Let me see really quick. I think it's volume 94. No, I can tell you on my rebuttal time what volume it is, but there's one volume in the record that is just the disclosure. And it's just a list of all of their names and then like 2 or 3 sentences about what they said. But some of it was damning. Like, for example, a couple of times they'd say things like, didn't remember him or thought he was a jerk or things like that. Or also they'd say need to follow up and then put other names that would like lead to additional witnesses. And that's what was disclosed. For example, next to Michelle Dory's summary, it says, we need to follow up with Deanna Wells. So it did contain impressions and work product, but they were minimized. However, I know that at the hearing, the prosecutor was crossing the witnesses with actual statements from their interviews. And I'm not sure under what provision that disclosure was compelled because it definitely.
Or whether it was compelled. I mean,
right.
I don't know.
I'm not clear, but there is prejudice that I can see that arose in the actual questioning of and the cross-examination of these people that resulted from the compelled disclosure, which is broader than any discovery order I was able to find. And I read hundreds of cases talking about this, and I never found anything rising to this level where it was every witness.
And I don't want to cut you off because this is like you've suggested, this is a death penalty case. We'll take as much time as you need, but what are you seeking from us today? And answer that in light of, I was not convinced that we should even be here today.
Right.
I dissented from this determination of having this proceeding and convinced me that I was wrong in that determination with what we know now. I mean, we know we're kind of where we were when this started. Where you start is we have a 75 IQ that's subject to some sort of give and take of 5 points, and that puts them in a low intellectual function that triggers all this. And I was skeptical of that initially, and tell me why I shouldn't be now, given with what we know, but also then what you're seeking. So I'll leave it open to you.
All right.
Yeah.
So
you probably thought about that. So go ahead.
we've thought a lot about what the ideal resolution is for both truth seeking and for Mr. Thurber in this case.
And also let me just the challenge, the seemingly maybe not impossible, because we do retrospective competency stuff all the time, those kinds of things in that arena. But the challenge of going back to 2009, not consider anything post factually from that, and that's very difficult. And go ahead and tell me what you want.
Yeah. Okay. So there's a couple ways this court can proceed from here. I remember your initial dissent well, and your suggestion that there's important penalty phase issues that need to be decided, and we're basically delaying that based on what I will admit.
And we'll be back, 3 or 4 years from now, if we get the relief.
Was somewhat paltry. So obviously, if this court decides the penalty phase issues and determines that he is entitled to a new penalty phase hearing, then it can remand this all back to start the penalty phase hearing again, at which point he can move for intellectual disability and present all of the evidence up till the time of his new penalty phase hearing, and do so both in support of his mitigation and as part of an Atkins hearing as contemplated by the statute. So in one way, you can address the penalty questions, and then this just becomes part of the remand, because if we remand for a new penalty phase hearing, this necessarily would be a part of it. On the flip side, a new penalty phase hearing isn't necessary if you find that he provided sufficient evidence, sufficient reason to believe he's entitled to not be executed, and that this error can't be cured and thus convert his sentence to one of life. Then we don't need to decide the penalty phase issues, because he's not going to be subjected to capital punishment. He would just be resentenced under the intellectual disability statute.
How can we do that without the independent court-appointed medical experts?
You can
That
find,
seems to me to be a big step.
you can find the information that he provided sufficient, that everything, all the testimony, everything you read and heard, that it meets the standards for intellectual disability, thus replacing the need for the independent experts. But I agree that in some ways takes the jury's finding a way about the sentence of death without the counsel of the independent appointed experts. So what I think is most likely is that it would need to be remanded for a full evidentiary hearing and the appointment of those experts that can provide a neutral opinion, because not shockingly, the experts in this case were divided on party lines. And that was exactly what various courts have warned against, that when we're making these determinations of competency and we're making these determinations about intellectual disability, we want to avoid biased experts dueling it out, because already, as I think it was the majority in Atkins and the dissent in Penry discussed, like, this is a factual determination. And unlike the penalty phase of a capital proceeding where they're weighing multiple factors, like, we're resting these decisions on a single factor. And so the need for objective fact-finding is at its highest in these situations.
Can I ask a follow-up
Sure.
on that remedy that you're requesting for a remand for a, I think, 6622C hearing? Am I getting the subsection correct?
I believe so, yeah.
That's the subsection with the independent experts.
Yes,
And I want to ask about our decision in Corbin, which we've already discussed. some.
yes.
Because in Corbin, that's exactly what Corbin asked in terms of the remedy. And we agreed with Corbin that the lower court had essentially screwed up the threshold determination.
Right.
But what we said was we denied Corbin's request for a 6622C remand. And this is what we said. Rather, we conclude the best course is to afford the district court an opportunity to review Corbin's motion again under the threshold standard. And then we said, but with a wider outlook. In that review, after again considering the reports that were provided by the defendant, the court may decide to allow additional evidence. And that sounds a lot like what already happened here. So I wanted to ask you to sort of give you a chance to respond to that language from Corbin.
No, I appreciate the opportunity, because that is what happened, and still they got it wrong. Still, the threshold wasn't applied as a threshold standard. The court didn't look, did he make a showing that there's a question of his intellectual disability?
Well, but when we in Corbin talk about the court may decide to allow additional evidence, I mean, that sure sounds like a fact finder weighing evidence, which is not what you want.
No, my understanding of that was the court may decide to allow additional evidence from the accused to meet the new standard. So the problem in both Corbin and in Mr. Thurber's case was that the law about how to establish an intellectual disability changed while their cases were pending. Right. So my understanding was the court may decide to allow the accused to modify its
You would have
position.
us read that language from Corbin, decide to allow additional evidence as limited to additional evidence from the defendant.
That is how I understood it.
Thank you.
And I think it would be different if the state had, it's not necessarily that the state can't put on evidence. If it at a preliminary hearing, for example, the defense can put on evidence, but it's only to be considered by the district court and by this court on review if it so negates something as to make it like impossible or impractical. I can find the quote, but like, it's not that it's never allowed, it's that it's just irrelevant unless it discounts an entire element of the crime, or it makes the witness's account so unbelievable as to render it like as to defeat probable cause entirely. And that's not what we have here. What we have is 4 experts who say the Flynn effect should apply to Nystrom's score, and we can look at Barnett's score even though his records were flooded. So we don't have, and the state's expert talked a lot about the Flynn effect and how it disagreed with how the ABAS adaptive deficits testing was done in this case. And those are valid considerations when determining does he actually have an intellectual disability. But they don't negate his prima facie showing that he had adaptive deficits. And it's certainly, the Flynn effect has nothing to do with Dr. Barnett's score at all. So it's not never that the state, like for example, if they had a witness that said, oh, I've discovered a 3rd IQ test and it's 125. And this is when he was trying to get into a special tech program for car racers. And that's, you know, when he would have performed the best. Like that might be relevant to negate some of the findings that we have here or to establish malingering, as the state argued. It's not that there would never be evidence the state could put on. It's simply that, does that evidence negate an element of the prima facie case? And in this case, the evidence doesn't. Does it undermine or undercut or weaken the evidentiary weight of some of his evidence? Sure, if you agree with their expert, it does. But that's the whole reason that we need a neutral determination. What we're asking for is that before Mr. Thurber is executed, if that's the route that we're going to go, that he be evaluated by someone neutrally to determine whether intellectual disability is a diagnosis or whether it's just something that these 2 parties have already spent 4 days debating.
And can I ask one final question,
Yes.
please, from me? Your statutory interpretation to support this prima facie is the correct standard, at least for the threshold inquiry. I understand your first argument is that it's inconsistent with the warden or sheriff making the request. And I don't know that I caught your.
Yeah, I never got to it, but yes, I have more reasons. So sorry, let me flip back to that page in my notes. It doesn't contemplate a hearing on a hearing. Like what procedural function, what gatekeeping function is served by the threshold standard if you have to have a hearing to determine whether you get a hearing? And moreover, it's a hearing before the claim has been able to be fully developed. This court limited the threshold inquiry, or suggested limiting the threshold inquiry, to pre-2009 evidence. But had this moved to a full evidentiary hearing, Mr. Thurber would have been examined not only by these 2 neutral people, but by his own expert, presumably by the state's experts as well. Like there would have been actual diagnostic information. And the district court, anyways, I'm going off track, but the district court here basically said no one diagnosed him, but then didn't allow him to get a diagnosis. She didn't let any testing be done. And she was like, none of these people can diagnose him. And they can't, of course, because you can't diagnose someone with an intellectual disability without an interview. And they couldn't interview him after 2009. So moving on, the ward of sheriff provision would be superfluous if the diagnosis of ID is a prerequisite to the hearing. The neutral expert part in the statute that it provides for it after the threshold highlights the issue that the plurality in Ford talked about, which is essential, a lodestone of due process when making a predicate fact determination prior to execution is the manner of selecting experts responsible for producing evidence be conducive to the formulation of neutral, sound, and professional judgment. Like Kansas was protecting that at the point of the hearing. Yeah, and then the fact that it says the hearing later means it didn't contemplate a hearing. It's not like you shall have a hearing to determine if there is sufficient reason to believe. Then you shall have a hearing on whether the criteria is met. It says you shall make a determination, is there sufficient reason to believe? Then you shall have a hearing. That is what the statute says. Now, do I think it's always wrong to have a hearing, or was it wrong to take testimony? Again, not necessarily. Like, he put on additional evidence of his prima facie case and had the state evidence that negated any of those elements. I think it would have been critical for the state to be able to put that on as well, but they didn't have evidence negating it. All of the factual questions raised by the defense's experts' critique of Mr. Thurber's prima facie case are exactly the kind of factual disputes best reserved for an evidentiary hearing. And numerous circuit courts have found that, like, even courts that are applying EDPA deference to state courts on matters of Atkins hearings say if there's a dispute, you get a hearing. For example, Wiley versus Epps out of the Fifth Circuit, I would highly suggest that as background reading for this case because it involved very similar facts. And in that case, the Fifth Circuit overruled Mississippi's denial of an evidentiary hearing for a petitioner who had IQ scores, I believe, of 73 and 78, for all of the reasons that we're asking for here. And they said, we don't even defer to the district court because the procedure, the due process, he didn't have a full opportunity to present his hearing. And I guess my final comment would be that even if this court completely disagrees with me and thinks that everything I have said is wrong and the district court and the state got it right, he's still entitled to a new threshold hearing because the standard wasn't clear before he went into it. And to the extent that he relied on other threshold determinations, he was reasonable in doing so. This court said it was a threshold inquiry in the order remanding, and it's a denial of due process to apply a more stringent version of a law to retroactively deny someone a hearing. So even if this court completely disagrees with me, and I don't think that they should, I think that my position is supported by the Constitution of the United States as well as the statutory language, he's still entitled to a due process hearing. And the best cases for this are Bowie versus City of Columbia, which is a 1964 US Supreme Court case, 378 US at 347. And then again, the Wiley v. Epps, the Fifth Circuit case from 2010, applying EDPA. So unfortunately, I don't think there's, short of converting his sentence to one of life, I don't think there's any way to avoid a remand constitutionally in this case in light of the innumerable factual and legal errors made by the district court.
Any other questions, colleagues? Thank you very much.
Thank you.
You reserve 3 minutes for this.
Thank you.
Mr. Elslager.
May it please the court, Chris Elslager, Deputy Solicitor General, appearing on behalf of the state. And I'm going to open with harmless error, not because I'm conceding any error, but because regardless of the standard of review, regardless of whether the district court got the standard for sufficient reason to believe right, regardless of any procedural errors, what we have before us is evidence that overwhelmingly establishes that Justin Thurber is not intellectually disabled. He's just not. And continuing to, remanding it again for any kind of additional hearing is not going to change that.
How can we go there when the statute specifically has in the process the independent court-appointed doctors?
Because, I mean, really,
if using your approach, he would not be getting the statutory process set out.
Because through his own evidence, his own experts failed to get him over the threshold. I mean, this is actually, we can go back to the original threshold decision made by the trial court before this was appealed the first time. Justice Rosen was right. He didn't meet the threshold. His own expert at the time said, he used the terminology at the time, mentally retarded rather than intellectually disabled, but Dr. Barnett said at the time, I'm not saying he's mentally retarded.
Then why did the state want to go to adaptive functioning discovery, which set back the process 2 years, when the court was all ready to go to look at those, look at the first prong, have a hearing, let them say whatever they're going to say about it, and then rule? You guys came in and said, no, we want to go to the second prong on adaptive functioning and delay everything a couple of years. And that doesn't, honestly, when I read in the transcript where the defense counsel said, we think the state's conceding that our test scores are going to get us low enough to where the other evidence of adaptive functioning is relevant, that kind of made sense to me, because why else would you open that door?
I think the state felt that because of the change in the law, from the United States Supreme Court, that this court recognized in the appeal, it caused them to remand it, that we had to do that. And I'm not sure that at that time that the state had, in the timeline, I don't know if they had Dr. Nystrom's report yet. And so I don't know that we even knew if we had a number yet.
I know at the hearing you had a report, the state lawyers had a report. I was going to say from a Dr. Fleischer is the name.
Fleischer was the state's expert, yeah.
But, and saying, everything the defendant's saying is false and not true. And here's our expert that says that. So we want to go to adaptive functioning.
Well, I think, you'd have to remember that when this was remanded, okay, the law had just changed from the United States Supreme Court. I can't remember the case name escapes me though, but they said you can't just rely on an IQ. You have to look at adaptive functioning. And then this court remanded because they said, well, you've got new case law that says you have to look at this. I think we all thought that it was required that you look at both prongs. Obviously, if you've got, as the court was asking, if you've got somebody who's got an IQ test like 120, 130, well, nobody can even, that clearly.
Back at the February 2020 hearing, the Assistant Attorney General prosecutor agreed to the process the district court had set out, which did not include looking at adaptive functioning. It was just going to look at the first prong. And the prosecution agreed with that, said the court was absolutely right. So something looks like it changed between February 2020 and you all getting the Fleischer report. One interpretation of that might be you thought you had problems at the first prong, so you wanted to move to the second prong and fight the battle there.
I don't know that that's true. I think that I wasn't the prosecutor down below.
I assure you, at the February 2020 hearing, the state agreed to just look at the first prong. I was looking at that last night.
Okay.
So I would have just been required.
That
It doesn't look to me like it was a given that you had to move to the second prong, at least at that point.
I will tell you this, that when the trial attorneys come to me and when they asked me about this, I was under the impression that you needed to cover both adaptive functioning and the IQ, that you had to do both. And I may have told them that, it might be my fault. I don't know, but because I don't remember, but I certainly read the case law as meaning you've got to do both. At least if it's close. And we have an IQ score that is in the 70s. And this is what I want to get back to, though, is, what is the whole point of this? The whole point of this truth-seeking function of the court is find out if Mr. Thurber is intellectually disabled or not. And we had something like half a dozen experts testify below, and none of them affirmatively diagnosed him as being intellectually disabled. His own experts testify that he was not intellectually disabled. We only have one actual IQ score, one actual test. Barnett, he was shooting from memory. He said he couldn't, I don't remember, he couldn't remember if he actually had given him an IQ test. I thought that he said he hadn't, but the one test that we have is from Dr. Nystrom, which was done at the request of the defense before trial back in, I think, 2009 or 2007. I can't remember the years. It's been a long time, but it was before trial. Their own expert tested him, and he came out with an IQ of 78. And then he testified prior to the trial. Now, at the time, the defense then buried that because they didn't have to reveal that to anyone. They just weren't going to bring it up, right? So, but they knew this even back before the trial. So then at the remand hearing, Dr. Nystrom, he stuck to his guns. He said with 95% confidence, Thurber's IQ is between 74 and 82. And he also said that he concluded there was no adaptive functioning disorder deficits. And he said that Thurber did not meet the criteria for mental retardation. Then you had Dr. Barnett come on, and he said the same thing. You look at his testimony in the trial initially, and he said that I want to make it clear, I do not say he's mentally retarded. I mean, that in itself to me, if I was the judge, I'd say, well, that you haven't met the threshold then. Your own expert says he's not mentally retarded. But then at the remand hearing, Barnett said the same thing. He was not willing to backtrack on that. He said, even with the benefit of the hindsight, the new information presented to him at the remand hearing, he still does not believe Thurber is intellectually disabled. And that's at record volume 101, 311 to 12. So his own experts said he wasn't intellectually disabled. And then you have, other records that was considered by the trial court in the first instance and by this court back in the first appeal that, he was seen by Cowley County Community Health, and there was 2 different doctors that saw him, and neither one gave any indication that they suspected intellectual disability. He completed 64 credit hours at Cowley County Community College with a 2.1 GPA, which is, not great, but an intellectually disabled person is not going to complete, 64 hours of community college. He was able to maintain multiple jobs. He was able to live independently. All of that indicates that he was not intellectually disabled. And, another thing to think about is Dr. Flesher, when Judge St. Peter asked him, he asked him some questions at the end of his testimony. And Dr. Flesher pointed out that the only reliable evidence of Thurber's IQ is the Dr. Nystrom report from prior to trial. And that at this point, you're never going to get another reliable report, ever. It's not going to happen because Thurber knows what's on the line. Do you think if he knows that if he's not intellectually disabled, he's going to face the death penalty? Do you think he's actually going to try on an IQ test? I mean, yeah, they can control for malingering, and all that tells them the test is invalid. But you're never going to get a valid IQ test. So, as a practical matter, as Dr. Flesher pointed out, the only evidence, the only reliable evidence, is what you have that was gathered before trial. Okay, and you've got Dr. Nystrom's report, you've got his testimony, you've got Dr. Barnett's testimony, which was consistent with Dr. Nystrom's, both at the original trial and at the remand. You've got the Cowley County mental health reports.
So can I stop you there because a question occurs to me. Mr. Thurber's counsel has asked us, and I think I'm getting this right, they can correct me when they come back if I don't, has asked us effectively, they've said, look, the district court screwed up this threshold determination by entering into the role of a fact finder, should have just looked at our evidence. And they've said to us as a reviewing court, you can look at that evidence and decide that it clears the threshold and order a subsection C hearing. That's how I understand one of their arguments, at least. And what I want to ask the state is, I understand you may not want to agree to that in some sort of absolute sense, but if that's an option in front of us, would you take the position? I mean, it sounds like you're taking the position that, look, we, the reviewing court, if that's the proper legal standard, we can just look at that evidence and decide that Mr. Thurber did not meet the threshold showing. Is that what you're asking us to do?
Yes.
Okay.
Yeah, I mean, he didn't meet the threshold.
If I can just clarify, it sounds like both parties in this appeal are claiming that we as a reviewing court, if we determine that the proper legal inquiry is limited to the evidence proffered by the defendant, both sides are saying you can look at that and we win.
Yeah, I think I'm couching it in terms of a harmless error analysis.
I know you were, and that's why I wanted to shift it really to an analysis of, in other words, we've got this whole universe of evidence. The defendant wants to say, nope, narrow the universe way down. And I understand you disagree with that,
right.
But for purposes of argument, you're making an alternative claim that, even if we narrow the universe of evidence, you as a reviewing court can still look at this and determine threshold was not met. That's what you're saying, right?
Yeah.
And I know you're couching it as harmlessness, but is it really a harmlessness?
Well, I think the reason I'm couching just to explain, because you have a question about the standard of review, whether it's abuse of discretion, and I don't I don't
Well, that's
want
what
you
I'm
to
trying
think
to-
that I'm suggesting you have a de novo review.
Well, that's what I'm trying to potentially sidestep. I mean, if, and again, I know you're not conceding this, but if we conclude that there was an abuse of discretion because an error of law was made, and that the proper universe of evidence is limited to the defense's proffer, their motion and so on. I mean, you're claiming that you still win, even if that's the case.
Yes.
And that's not a harmlessness review. That's a sort of a substantive review. That's what you're saying. You're saying, look at the evidence. It doesn't clear the threshold.
Yeah, I mean, I guess I look at it harmlessness. We often look at harmless error. You look at is the evidence overwhelming?
Kind of the difference would be harmlessness might be if we send it back with this narrower threshold, your argument is, look, the judge is just going to look at this and come to the same result.
Yes,
Okay.
that would be accurate as well.
And if this court does look at the record and do that kind of review, we should do it in the light most favorable to the defendant.
Well, that's their argument. I'm not sure I would agree with that. I think you
So
should.
then how do we look at it? What's the stand? I mean, if you're saying we can look at it, through what lens do we look at it?
Well, I will say this: if you do look at it in the light most favorable to the defense, they still lose. I mean, they're just, like I said, it doesn't matter the standard of review. There is just no way that Mr. Thurber can establish the threshold question that he's he might be intellectually disabled, because the evidence shows he's just not. He's just not intellectually disabled. I mean, there's just no evidence of it. He tried and tried and tried at the hearing below, and he just can't get it. The best he could get were some of the doctors saying, well, I don't know if he's intellectually disabled or not. I'll just maybe we should do more testing. That's as far as they could go. No one at the hearing below affirmatively said that they believed that he was intellectually disabled. And the ones who were who did actually make a diagnosis, the ones who actually interviewed him, did a psychological evaluation, tested him, which are just Nystrom and Barnett, both said he's not. He doesn't meet the criteria. Then you can look at all the other evidence, as the dissent did in the first time around, and I don't know how you could conclude that there's any possible way you could think this guy's intellectually disabled. You know, he went to college. He had multiple jobs.
We've heard all that.
Okay.
So I guess what I didn't see in the state's request to move these proceedings over to the adaptive functioning discovery, that you told the district court about Corbin saying that the threshold determination is done without a hearing. And it expressly says that.
Well,
So did I miss something? Did the state advise the district court that there's this Supreme Court decision out there that expressly says you do it without a hearing?
I don't know, because you're bringing up something that, quite honestly, this wasn't briefed. I don't remember that part of the record. I probably didn't even review that part of the record. I don't remember that, because that wasn't something that they raised on appeal. So what's anything I focus on? I don't know what the prosecutor said to the judge. I do know that this is a unique procedural situation. This is the only case I know of that, well, outside of the Van Cleve hearings, mid appeal. I mean, where we have affirmed the convictions, but with the penalty phase still pending, it's remanded, and it's remanded to the court, to the trial court, with relatively limited guidance, other than what Justice Stiegel pointed out, basically telling the district court judge, kind of at your discretion, figure it out. And I was down for I was there for the hearing itself, and I can tell you, I watched Judge St. Peter. He struggled with some of these questions from the remand. He asked questions of both counsel. What do you guys think this remand means? He went and did his homework. He looked up other case law and so on, and he was doing the best he could with the limited guidance that came from this court. I mean, the remand, I mean, Justice Stiegel described it well. I mean, it basically said, district court, go back and relook at this. It's at your discretion. Figure it out. And that's what Judge St. Peter did. And I think, the parties were also in the same same kind of boat. I mean, we had questions too about, okay, well, what's the procedure? What's the procedure? Because it's not pre-trial. So the pre-trial rules, they don't seem to apply. It's not a 1507, and there really aren't a whole lot of procedural rules for 1507s anyway. What's the procedure? And so everyone was trying to figure out the procedures. And you add to that the fact that there was a change in the law, which is why the remand was there, is to figure out what meets intellectual disability. It used to be, quite honestly, under the old law, that IQ 78 score, that's it, we're done. He's not intellectually disabled. But we're remanded now that we have to consider adaptive functioning because the Supreme Court told us to, the U.S. Supreme Court and this court. And I think everybody's trying to figure it out. So this is a unique case. I would suggest that this not be the case to set the standard for all future cases because it's so unique the way it was remanded mid-appeal. And to the extent the district court made some errors, I would first submit again, they were harmless in the grand scheme of things. And I feel like most of this stuff the parties agreed to. To the extent that they're, the only two things they've raised on this appeal are that the district court applied the wrong threshold standard and the discovery order. So the things that you're bringing up, I can't really give you good answers because that wasn't really within the issues that they raised on appeal.
Well, having a hearing, allowing the state to present evidence at the threshold stage seems to be a fairly easy thing to look at the statute and to look at the case law interpreting the statute and follow.
And the district court did that in the first instance, and this court remanded it. So I think the district court was looking at, well, okay.
Changed after but it's very clear in Thurber 1, we said the district court applied the standard that was applicable. The problem is the law changed, including the legislature changing the law and making it retroactive while the case was on appeal. That happens. The law changes while something's on appeal, and the parties have to adapt to it. Let me move you over to the discovery order. Would you agree that the intellectual disability hearing in a capital penalty phase is part of the trial?
Yeah, I mean, it came up. I mean, that's the way it came up in the first instance.
The 2232-12 has to apply.
Well, again, I don't know that because of the confusing nature. This came back on a remand where the convictions had been affirmed. So he was now
penalty phase. So we're talking about the penalty.
Yeah,
penalty phase, part of a capital trial.
Yes. Yeah.
So why wouldn't 2232-12 apply?
Well, I think the reason being is because those are pre-trial. Right now we're mid-trial. In fact, we're post-trial. This is what's confusing about it. And I'm not. Maybe I'm just not that smart, and maybe the attorneys below were not that smart, and the judge was not that smart. It came back, and this is a strange posture. That's all I can tell you. Did they make mistakes? Possibly. I mean, you apparently believe that it was. I'm just judging from the
trying to figure out why 2232-12 wouldn't apply to the penalty phase of a capital murder case. And this is clearly part of the penalty.
You're talking about 2230. That's the discovery.
Yeah.
Well, it would prior to the trial, and I think that's why we argued it didn't apply. And I think that's why below there, because it came back after the convictions had been affirmed on appeal and it was on a remand. And then you have to agree that's very unique. Okay, so maybe it should have applied. In the grand scheme of things, again, though, I'm going to submit to you that it's a harmless error. I mean, at the end of the day, what we're really trying to get to is the court's truth-seeking function. What we're really trying to get to, what's the reason we're here? Is Justin Thurber intellectually disabled?
Can I ask a question about that? Assume for the purpose of my question, if we agree with the defense argument that this threshold inquiry is limited to the filings and even potentially additional evidence presented by the defendant, if we were to agree with that, and then we either have to analyze whether it's harmless, or as we talked about earlier, maybe this court could do that review. My sense is that renders the discovery dispute irrelevant, because the discovery, I mean, to the extent the discovery dispute has any relevance, it only goes to those later proceedings where there's a hearing. And so,
I would agree with
so
that.
do you, and I'll probably plan to ask the same question to opposing counsel, but just to clarify, if we limit our review just to Mr. Thurber showing, it doesn't matter what happened in the discovery dispute.
Yeah, I would agree with that. And I just want to, as I flip through my notes, I want to come back to the discovery issue. You just talked about the nature of remedy, and opposing counsel already touched on this. And the cases I looked at all pretty much say the same. As a practical matter, there is no remedy. Okay, the state can't unknow what it knows. Nobody, you can't. So there's no remedy. And what the cases I found, how the approach to this is that the proper thing to do if you get faced with a discovery order that you think is improper and unlawful is to file either some kind of an interlocutory appeal or a mandamus action. As the court already alluded to, they could have filed a mandamus action to try to stop an original action of this court, not an appeal, because she focused on the inability to file an appeal, but they could have filed a mandamus action as an original action. The other thing, because of the unique state of this case, it was still on appeal. Okay, the appeal was stayed. This court retained jurisdiction and sent it back to this limited remand. They could have appealed that order within that context, because they certainly did so in other contexts. They filed a motion in this court to expand the scope of the remand after the Hodes decision, and we opposed it. The court granted it and sent it back down. So they clearly knew how to ask this court for more, to do more, to grant their requests and so on. Because I think, well, I don't recall if the district court below initially was hesitant to expand the remand, but I do know that they filed a motion to expand the scope of the remand to include the Hodes question, and the court granted it. So if they thought that there was an improper discovery order, they should have sought review by this court right away. And so I would submit that not only is there no remedy, I would submit that they essentially waived the claim because they took no action to fight it. And all of the cases I found dealing with discovery order, improper discovery orders, they were all mandamus actions. They're all from, I couldn't find, there's obviously not one from Kansas. They're from Texas and elsewhere that said basically you have to file a mandamus action to give an appellate court a chance to rule on it, because otherwise the party is without an adequate remedy by appeal, because an appellate court would not be able to cure the improper discovery order. And that's from a Texas case. If you're interested, I can give you the site, but the case is in Ray Juniper Venture of Texas. It's a civil case, but there really is no remedy. And that's a practical matter. It just, you can't, as she said, we can't unring the bell. And again, as you point out, it's really kind of harmless. I mean, you can look at the evidence. I mean, you can get back to what I opened with. You look at the evidence, and you can look at the evidence from Mr. Thurber's own experts. You can ignore the state's expert, Dr. Flesher. Look at just his experts. He doesn't get there. He just can't get there. The evidence is just not, it's not there.
Push back on that, because it hurts me that if we were to remand back with an order that says whatever the defendant submitted meets the threshold, so the court needs to appoint experts, and then you get to go have your full hearing with all the experts and court-appointed experts and stuff. How do we know that what you can't unknow doesn't help you work against the interests of the defendant based on a discovery order that should not have been entered?
Well, that's why I said there's no remedy. And that's why I've submitted, they've waived the argument.
Well, that might be, a really good IAC issue in the habeas proceedings that are coming, but I'm trying to figure out, how do we give this guy a fair hearing on intellectual disability if it goes back when you guys have been through the files, when you have this information that they've given you about all these witnesses, and you've been able to go out and develop and all that?
Well, two things. As I started with, there is no remedy. One, and two, I would submit he got a fair hearing. He got much more than the regular threshold hearing. He got a full hearing. He essentially got the second phase of this. Didn't appoint two neutral experts. Instead, he got 5 or 6 of his own experts, and the state presented one. but he got a very thorough, I mean, what more would you put on
I
at a
think all
hearing
you have
below?
to do is follow the statute though. And the statute says there's supposed to be some independent people working for the court that sits between the battle of the parties experts. And that's missing here.
And I will respond to that with the two things. One I already mentioned, is Dr. Flesher astutely pointed out, it doesn't matter if you put neutral people to test him, you're never going to get a valid test result out of Justin Thurber again, ever. The other thing is,
So
I go back to harmlessness.
Experts analysis.
I'm sorry, start over.
You should credit your expert's analysis that it doesn't do any good to have the procedure that the legislature mandated.
Well, I don't think you need to credit the expert's analysis. I mean, I think you just need to, I mean, it's just common sense. I mean, I think you'll all with logic come to that same conclusion. Justin Thurber knows that if he is not intellectually disabled, he's facing the death penalty. If he is intellectually disabled, he's not facing the death penalty. The power to score, how high he scores on that test, on an IQ test, is all within his power. So do you think he's going to try to perform his best, knowing that if he performs his best and he's not intellectually disabled, he's going to face the death penalty? The problem is while they can catch him malingering, fine, that just invalidates the test. You'll never get a valid test.
And you think that's just undisputed across the profession? There wouldn't be anybody that would come in and tell the court on an independent basis, you know what, we can catch people when they're trying to cheat.
No, they can catch people. The problem is they can't make them perform at their best. I mean, they can catch the malingering and that invalidates the test. They can't make him perform at his best, so you're never going to get a valid test result. And I don't think that's a matter of you need a psychiatrist or psychological expert to tell you that. I think that's logic. I think we can all agree to that. But again, your point is, I understand your point is that, yeah, we haven't followed the statute, right? Got it. And I'm telling you, I think it's harmless. It's harmless in the context of what happened below. You've got so much evidence. And at the end of the day, the whole point of the court is this truth-seeking function. Get to the truth. And the question is Justin Thurber intellectually disabled? He's not. His own evidence establishes that. It was actually, to me, it was obvious at the end of the first trial and the first appeal, but apparently only to one of you that were on the court at the time. So
well, let me push back a little bit on that. That might have been the position then, but once this court determined he's entitled to the hearing, what's wrong with us giving direction with do it right? And I appreciate we didn't give much direction there, but now that we're here, what's wrong with sending it back and saying, here's the procedure, adopt the procedure? What's wrong with that?
There's nothing wrong with it. I think it's impractical. It's just like the question about the remedy for the discovery order. There's no practical remedy because you can't unknow. There's no way, if you send it back, there's no way that you're going to get any better evidence, you're not going to get another valid IQ test. The only IQ test we have is Dr. Nystrom's. That's the only valid one. And sending it back I had this conversation, the first appeal. I had a long discourse, I think, with Justice Breyer about, I was pushing back hard. We don't need to remand this. Let's just get the appeal over and then he can bring this up in a subsequent motion. And she was like, well, don't you want to know now? And, it took us 8 years to get back here. And we've had as much evidence as we're going to collect. Another remand is not going to generate anything different. Okay, he's not going to suddenly become intellectually disabled.
So what happens on the next time we do a hearing or hearings warranted on intellectual disability? What direction does the trial court has as a result of what happened here? I don't think there's any if we follow what you want.
Well, I mean, I don't want to, how do I say this? In a remand order, if this happens again, you need to give the district court more direction. You could use this case to say, look, if this happens again, you need to do X, Y, and Z. The discovery order, the discovery statute applies and whatever, but we can't undo what's been done. And a remand is not going to produce anything useful for the court for the truth-seeking function for the underlying question. The errors that were committed, as I started with, if the court believes that there were errors committed in the procedure with the discovery order, et cetera, those errors are all harmless because at the end of the day, Mr. Thurber was able to put on all the evidence that he could, all that he had, multiple experts, not a one of them said that he was intellectually disabled. His own experts, the ones that actually evaluated him, said that he did not meet the criteria for intellectual disability. Then you look at all the other evidence that we've already talked about, and I know Justice Biles does not want me to hear me go over it all again. He clearly did not have any deficits in adaptive functioning that prevented him from engaging in independent living and so on. His IQ score was 7. The one score we have is 78. That's above the threshold, well above the threshold, well above the standard error measurement. Add that to the clear adaptive functioning that he had. He just is not intellectually disabled. And when you boil it down, that's the real question we're trying to answer. That question's answered. It's answered. Any more, another remand is not going to change that.
But I assume you're not just conceding that the district court did it wrong, that, one of the threshold questions, at least in my mind, is whether a district court judge in making the initial determination can resolve fact disputes and make credibility assessments or not. Or is it just a question of whether the statute is asking the district court to decide whether there's a prima facie case that there is reason to believe an intellectual disability may exist? So under the statute, I assume that you believe that the former is true, that the district judge has some ability to assess the evidence at the first phase. And what is your view? Would you have us interpret the statute?
Okay, well, I want to start with, as I opened with, I'm not conceding any error, but I launched on the harmless error because I think it doesn't matter. And Justice Biles pushed on me pretty hard that, so I mean, if he sees error, I'm telling you it's harmless. But I agree with your assessment of the threshold question. The judge is I mean, if the judge can't analyze the evidence in front of him and do some weighing and make some judgment based on that evidence at that threshold hearing, then the threshold hearing is just a formality. It's just, if you're just saying that if the defendant says, hey, I'm intellectually disabled, okay, we go on to a full hearing. He has to show enough. And the judge, I mean, that's why we have judges. The judge has to look at that evidence and come to a reasoned conclusion, whether that's sufficient or not.
Is there something particular in the statutory language, though, that you're relying on to bolster that, or is it just ambiguous and we have to sort of do some exploration under statutory canons, or canons of interpretation?
Without the statute in front of me, I don't think there's I believe the statute reads that if he presents it, the judge then has to make a determination. It just says if there is sufficient reason to believe. But I think actually it reads, if there's not sufficient reason to believe he's intellectually disabled, you move on to sentencing. If there is sufficient evidence or sufficient reason, doesn't say have a sufficient reason to believe that he is intellectually disabled, then you move on to the next phase, the full hearing. I don't think the statute, and I think that's part of the problem that the judge wrestled with down below, is that the statute doesn't say, it doesn't really articulate what sufficient reason to believe means. It doesn't have any guidance for, if I recall right, it doesn't have any guidance for how to consider the evidence. I think it's just assume it's a judge. He does what judges do. He assesses the evidence, weighs it, looks at whether it's credible or not, and makes it a first assessment of whether or not there's sufficient reason to believe that the defendant is intellectually disabled. And I think that, I don't think the statute gives them any more guidance than that.
Let's focus on the statutory interpretation part. The reference to a hearing comes in that statute only after you've had the court-appointed doctors, and then you're having the fight, which is why I think the Corbin language about you make the threshold determination without a hearing occurs. you don't really want to suggest that the legislature intended for there to be a 3 or 4 day trial over the threshold question, just to then appoint court-appointed appraisers, then to come back and do a whole nother 3 or 4 days of evidentiary hearing for the final determination. That doesn't make any sense to me at all. And there's no parallel to it in any of the other statutes, competency hearing, those kind of things. So again, just looking at the language, where does it tell you that a full-blown 3 or 4 day evidentiary hearing occurs at the threshold determination?
Justice Biles, I'm happy that we finally got to a point where we both agree that you're right. I don't think the legislature intended that. What happened here was unique because of the posture of the case, the way it was remanded, and I think there's confusion among the judge and the parties. No, yeah, I absolutely agree. No, I think what the legislature intended was kind of like what happened in the first instance in this case when it was brought up, and the judge said, "Okay, defense, make your prima facie case." I think they had Dr. Barnett testify. I can't remember what other evidence they had, and then the judge said something along the lines of, "Look, okay, well, I'm going to consider all the evidence that has been presented in the trial, in the pretrial hearings." And from this hearing, and so I can't remember the exact language, but basically I'm going to consider the totality of the evidence in front of me. And I found that he hasn't made the threshold showing because of the litany of things I've already said that I'm not going to repeat to irritate you again. But no, I agree. I don't think that and that's why I said I'm not sure this case should be used as the guidepost for all future cases, because I think what happened here was unique. It was weird. It did not really match the statute, and I can only attribute that to the fact that it was remanded midstream, and there had been a threshold showing. The court didn't say that the district court was wrong in the threshold showing. It didn't reverse. It just said, look at it again. And I think, and then there was
the applicable standard, which had changed since it was made, that since it existed. The day before the sentencing proceeding. That's the problem. That's the only thing that's unique about this, is that the standards change. It doesn't mean the statutory process changed, or that the statutory process could change.
No, I agree. I mean, I'm not saying that what the district court did holding this big 4-day hearing, I'm not saying that was the right thing to do. I'm just telling you, I mean, we know that's what the court did. It seemed to be that's what the parties wanted. In fact, again, the other side wanted to expand the scope of the remand to include the Hodes question about whether the death penalty violated the Kansas Constitution, and this court allowed that. And I can tell you, me sitting in my office away from the trial attorneys, I'm pulling my hair going, why is this taking so long? What are you guys doing? And they're coming back and telling me, well, this is what we have to do because we have to have this, I mean, it did not follow the procedure. I can't dispute that. But what I'm telling you is that in the end of the day, what I opened with, the grand scheme of things, any error in this case was harmless. It just doesn't matter, because the ultimate question is Justin Thurber intellectually disabled? And the evidence clearly shows no, he's not intellectually disabled. And I'm a little frustrated. I mean, can we move off this now? Can we move on to the other issues in the case and move, because he's not intellectually disabled. This has delayed the case for 8 years, and the judge made the right call the first time around. He's not intellectually disabled. There's just no evidence to support that. There's no way, I don't care what procedure you give him, he can't make that threshold showing because it's not there. And that's it. I know Justice Biles is frustrated because you seem to be. I'm frustrated too. It didn't follow the right procedure, but here we are.
I just want to stay on the issues that the court wants to talk about. And, I think we know that he went to community college and he was 1 or 2 classes short of graduating. I mean, we don't need to repeat that litany. We know that, but we need to figure out some of these legal issues to figure out whether they're meaningful or not.
Well, as I submitted,
they don't. This guy's guilty. He doesn't have an intellectual disability. Let's get on with it.
Well, my argument is not that arbitrary. I'm telling you, the evidence makes those errors harmless. Yes, the procedures were not followed correctly, and it didn't prejudice Mr. Thurber. In fact, if anything, it benefited him because he got a much larger threshold hearing than he could have gotten under the statute, and he still failed to meet the threshold. With, I don't know, half a dozen experts testifying on his behalf, he failed to meet the threshold because his own experts said he's not intellectually disabled.
Okay. Mr. Ellsler, you have anything else you'd like to add?
Let me just make sure that there were some questions by the court that I think that we've covered. I think we've covered just about everything. If there are no further questions from this court.
Any further questions? Justice
I
Wall, go ahead.
hate to ask, but
I shouldn't have asked.
yeah, sorry
No,
to
no,
extend it, but I do have
Go ahead.
one question, maybe pushing back on your conclusion. What you're characterizing it harmless, but I'm saying whether or not, if you view the evidence in the light most favorable to the defendant, I think even the district court in its findings said, hey, if you take the IQ score, apply a standard deviation and the Flynn factor, there is reason to believe. So
But the district
is it,
court,
if we are just reviewing the defendant's evidence, if that is the standard, you see where I'm headed?
well, you get into the Flynn effect because the court kind of said that rhetorically. He said, if you do it, this happens. If you don't, he's not.
Right.
And ultimately the court declined to apply the Flynn
Correct.
factor.
Right.
And I think that the evidence that
It made findings that it shouldn't apply it in a mathematical manner to reach the conclusion that there was reason to believe, but that was based on, evident findings based on the evidence, right?
right.
Yeah.
And so, I mean, again, the experts were all generally consistent with one exception. The experts, Dr. Durrett was the only one who said that she would apply a mathematical subtraction, although she said she ultimately concluded that that's actually not the best way to apply the Flynn effect.
Didn't she admit that even the DSM says don't do that?
Yes, the DSM says don't do that. The people who make the IQ test say don't do that.
And that was the defense expert. Correct?
Yes.
And so even if we are in the realm of only considering defense evidence,
Yes.
that
Even and
would be fair game under the defendant's theory of how this should have proceeded.
right. Even Dr. Nystrom, also their witness, said no. There's no. You don't make a mathematical subtraction for that because the DSM doesn't call for it. I think he said there's no formula. There's no algorithm. You don't do that. The very first expert that they put on, Dr. Reshley, who was really more of a he was really essentially a teacher for the court. He discussed all that, described it, and he said you don't do it for an individual. It's a collective phenomenon. There is no procedure or accepted method for applying it to an individual, because I think he said something along the lines of, I don't have the quote in here, but we don't know if the group effect applies to an individual. So every expert said don't do that. The only one who suggested maybe you should do it was Dr. Durrett. But all of the other experts from the defense side said, no, you don't apply, you don't take the Flynn factors and just do a mathematical subtraction because that's inappropriate. The DSM doesn't call for that. It says don't do it. The people who make the IQ test say don't do it. Again, of the 5 experts or 5 or 6 experts other than Dr. Durrett said don't do it.
And who's the person that testified to that? I missed the very first part of your sentence.
Dr. Durrett was one of Thurber's experts. She was the only one who suggested doing just a straight subtraction. Dr. Reshley was the very first witness, and he was the kind of the learned expert in the field who just kind of educated everybody on this stuff. And he talked about the Flynn effect, and he said it's a collective phenomenon, not an individual one. We don't know if it applies to individuals, so we don't do that. Dr. Nystrom, also a defense expert, said the DSM doesn't call for doing that. There's no formula. There's no algorithm. That I can't remember the exact terms, but basically said that would be professionally inappropriate. It'd just be inappropriate to do. I don't recall if Dr. Barnett opined on it, but the general consensus, the overwhelming majority consensus of the defense experts was that you don't.
Of the defense experts?
Of the defense experts was that you do not subtract. You don't do a mathematical subtraction for the Flynn effect.
So if we're applying a light in the favor of the defendant, and we're basing it only on what the defendant produces, we wouldn't consider the defense evidence, right?
If you're, I'm sorry, say
We're
that.
doing a threshold determination. And it would be just based on the showings made by the defendant. You don't get to come and play to bring in other opinions or evidence. You might be able to cross-examine witnesses if that's what the court's doing on the defense side, but you don't get to come in and counter the evidence. So if we're doing the analysis that we're talking about here,
Yes.
we only look at what they submitted. Right?
Yes, if you're doing that now. So you leave Dr. Flesher out, but you look at all the other
That's
doctors.
fine. I
Yeah.
understand that
Yeah.
part.
Yeah.
And if they contradict, then, there's something for the state to talk about there. I'm just saying we don't look at the defense experts if we're doing our own review based on what they submitted, which is,
Well, you don't look at the defense experts?
why would we, if the threshold determination is whatever
Okay.
either the defense counsel, the warden, or the sheriff shows up with. And I don't think the warden and the sheriff want to go through an adversarial 3-day trial, but if we're just looking at what that is, and the district court's only supposed to look at what that is, we wouldn't look at your submission.
Well, you wouldn't even look at the Flynn effect then,
Yeah.
because that was their experts that brought that out. If you're not gonna look at their experts, then.
We're looking at their experts. We're not going to look at your experts.
Oh, right, okay, right. So.
Oh, I'm getting it.
So, yes,
Trying to figure out how we filter our review, if that's what we're going to do under that.
yeah, and if you're looking at the defense experts, again, I mean, if we're getting back there, they said you don't do this mathematical subtraction for the Flynn effect.
Right. But if the decision is to be made based on what only the defense brings, we just look at the defense. And then,
Right.
and I can understand contradictions in there. That's fine. We just don't get to look at what the state does.
Right, but I'm saying, but they're experts, the
I
defense
understand.
experts did
Yeah.
that. So even if you look at theirs, I mean, I don't know how you can look at a light most favorable when you can't change the expert's testimony. You can't flip it. They said you don't do this, and that was their evidence, not the state's. I mean, the state also produced evidence that was consistent with that. But if you're going to push that out and just look at the defense side, again, even his experts
I understand.
said don't do that.
Any other questions, though? Mr.
Okay.
Elslager, would you like to sum up in,
I think I've spoken enough, and I would simply ask that you affirm the district court and consider the rest of the appeal.
thank you. Thank you very much, Mr. Elslager. Ms. Subject, you reserve 3 minutes. Let's see if we hold you to that.
May it please the court. First, I think it's really important to correct some factual statements that opposing counsel made. Here, and I'm quoting, Mr. Thurber is a person with intellectual disability. Dr. Logan Defense Exhibit 6F, admitted at the hearing and attached to his original submission. Dr. Barnett, I believe there is sufficient reason to believe that Justin Thurber has an intellectual disability with concomitant social and functional deficits that need further evaluation and diagnosis. Defendant's Exhibit 5C. Peterson said, on and prior to March 2009, Justin Thurber met the current diagnostic criteria for intellectual developmental disorder, intellectual disability in the mild to moderate range of severity. By numbers alone, Justin Thurber demonstrated borderline intellectual functioning plus many adaptive deficits. His academic performance was always well below grade level. These deficits were perceived in school, home, at the doctor, and in his neighborhood. He did not receive any adaptive academic or behavioral assessment or interventions during his education, though a simple review of his school documentation indicates they were completely justified. Defendant's Exhibit 10A, page 6. Further, intellectual functioning deficits such as problems with reasoning, problem solving, planning, abstract thinking, judgment, academic learning from experiences were evident in childhood interviews as well as through the adaptive behavior summaries. He demonstrated adaptive deficits that failed to meet developmental and social cultural standards for personal independence and social responsibility during the developmental years, and he continues to demonstrate those. It goes on to talk about, that's Dr. Peterson, and that's also on pages 6 through 8 through his exhibit 10. Dr. Durrett, I see potential for ID after only reviewing his school records. These provide an overview as well as specific examples of developmental deficits in practical skills, including social skills, independent living, and work functioning. In combination with previously reviewed records indicating significantly below average intellectual ability, I again see evidence for potential intellectual disability. The reason that this is important, that you know that all of these experts opined that he had an intellectual disability, it's very important, because obviously it defeats the idea that there's no evidence. No one could think this guy is intellectually disabled. I'm so glad that Mr. Elslinger has that opinion, having never spoken with Mr. Thurber, nor did his expert. There is extreme evidence of intellectual disability, and all of this was garnered even though the district court prohibited any of these people from actually talking to him. He couldn't have them interview him to get the full diagnosis because the court was limiting any examination of Mr. Thurber because it didn't occur prior to 2009. So to the extent that he doesn't have like a piece of paper saying, I'm intellectually disabled, sign me up for the AAID, it's because the district court precluded him from getting it. So we can't say that he failed to meet this ridiculous threshold he had no notion that he was required to meet when it was the court that prohibited him from doing that. And we can't say that there's no evidence when we have 4 experts who testified that he met the criteria. And this wasn't specifically based on the Flynn effect because we have Dr. Barnett's IQ of 75 with a 5-point standard of error measurement that gets us there even if we throw out Dr. Nystrom's. Also, the state repeatedly went back to the idea that we're here for a truth-seeking function. Well, then let's get to the truth. Let's let him take an IQ test that wasn't 14 years out of date and the doctor didn't even recognize it. And the Dr. Nystrom, who opined he had no intellectual disability, never even did any interviews with anyone other than the accused. And in the DSM-5 TR, it says that's specifically against clinical practice because people who have intellectual disability don't want to believe they have an intellectual disability. There's a stigma attached. It's embarrassing. Moreover, the fact that he went to college and had a girlfriend and lived independently, those are all stereotypes about what intellectually disabled people can and can't do. And they're frankly offensive. Like, that's why when we weigh whether or not someone has an intellectual disability, we don't look at strengths. In some ways, Justin's academics are actually a relative strength of his compared to his ability to remember to take a shower and his managers having to correct him and remind him that you can't smell when you're selling fast food. So looking at all of the evidence, there is plenty here to support a prima facie determination. Moreover, there's a gross misunderstanding of the Flynn effect by both the district court and the prosecutor about how it's like a group effect and we don't know if it applies to the individual. The Flynn effect basically explains that over time, the norm goes up. The population's IQ rises 0.3 per year after the test is normed. And it's normed at 100. So after 15 years, when the test is out of date and a new test has been submitted, and that is what is supposed to be being used, the norm on the old IQ test would be 104. So Justin Thurber had an IQ of 78 out of 104. So how do we norm that? Well, the simplest way to do it is just subtract 4 from both, because that would make it back to 100, which means out of a total of 100, his IQ is actually 74 and not, or 69 if you subtract the margin of error. The point is,
You mean that it would have been
had the norm been properly established, because what the test tells us is that his IQ was 78 out of 104. And so there really is no way to consider the Flynn effect without applying it mathematically. And you don't apply it to adjust the accused score, you apply it to adjust the norm. But then to compare that score to other scores, you have to adjust the norm.
Can I ask a quick basic question?
Yes.
Which I promised to ask you in my exchange with the state.
Yes.
If we adopt your preferred sort of way of looking at this and consider only the evidence put forward by the defendant, would you agree that the discovery dispute falls away and becomes irrelevant?
I wish, because that would be the cleanest thing for my client and for this court. But no, because unfortunately, if you remand it back for the full evidentiary hearing, you determine that yes, he satisfied the prima facie threshold. The prosecutor can't unknow it.
So you think that the discovery dispute and the potential prejudice to your client the prejudice would extend into the subsection C hearing, which is what you're asking?
Yes.
Okay.
I do think that it would. That said, the United States Supreme Court has said vacating an adverse judgment and remanding for a new trial in which the protected material and the fruits are excluded from evidence is an appropriate remedy. And that was Mohawk Industries 558 US
And
100.
just quick follow-up. If we were to follow your preferred legal framework, but then rule against Mr. Thurber, which is what the state's asking us to do, would you then agree, and I know you don't like it, but would you agree that if that's the case, the discovery error, if it was error, can't have prejudiced you in any way?
Not necessarily, because
Let me understand that. In other words, if we apply a review, which that you're asking for. and
right, if you
consider
find that
only-
we didn't present a prima facie case, that you disregard Barnett's
It doesn't
IQ,
matter what happened with discovery, if that's the case.
well, that assumes also that you affirm that the penalty phase was fair and full of error and doesn't require reversal.
Well, right, we setting
Because
aside all the other.
assuming you find against him on every claim that we have raised, then of course it would be moot because it didn't infect the proceedings that already occurred. However, there was, as this court is I'm sure aware, and we have briefed thoroughly, a lot of errors in the penalty phase, including, the sexual sadism angle, the things that were not statutory mitigators, that he had utter indifference to his parents when he committed the offense, for example. Those are pretty big errors that are likely going to require a new penalty phase hearing. And at that point, the discovery violation could have led to other people willing to testify against the client and say, oh, he's always been this, or to go against the mitigators. So no, I think that there would have to be some compelled order against future use and redaction, even if you find against us. But I strongly encourage you not to find against us on the intellectual disability matter. If we really want the truth, why can't we have a neutral person determine it? And the state says, oh, well, you'll never get a valid IQ. You'll never get a valid IQ. But that's exactly what the statute provides. Everyone who raises the specter of intellectual disability under 6621, where 216622, knows that the potential sentence is lessened if they're intellectually disabled. But that is what the statute provides for. And of course, there are internal validity measures that can be controlled for. And of course, the state can attack any evidence the defense eventually puts on or the court eventually obtains neutrally. Like, this doesn't mean that if he gets a lower IQ score, it's answered. And if he never gets a valid IQ score and we're left with only what we have now, then that's a different problem. But on the facts as we have them, where no one was actually allowed to diagnose him, and he just happened not to have a diagnosis of intellectual disability before the hearing, we can't say to meet the threshold standard, you have to be diagnosed as intellectually disabled. And this is talked about in Atkins and Hall, like in Penry in the dissent. People that are mildly intellectually disabled may be indistinguishable from other people who simply have lower IQs in many ways. They are not discovered until adulthood. They have jobs, they have families, they go to community college and get D averages. They exist in society and you can't just look and point them out. And because of this, it's not uncommon, especially coming from a rural Kansas school district in the 80s when there wasn't a ton of education funding, for people to be missed. So the fact that he didn't have a conclusive ID diagnosis prior to his arrest is not shocking, and it shouldn't prevent him from getting one now. But that's exactly what the district court did when they said, we're going to require these experts to diagnose you. Oh, wait, but diagnosis requires an interview and we're not going to let them talk to you because that would be after 2009. But you know what doesn't require an interview? Saying someone isn't intellectually disabled. You don't have to talk to someone to opine that they don't meet the criteria for a condition. So it's playing with the difference of the medical profession. And because of that, its reliability is extremely low at a point in time before his sentence or his penalty has been affirmed on appeal, before his sentence is final, where heightened reliability attaches. And I don't think we can look at this proceeding and say for 100% certainty that he is not intellectually disabled. I believe he is intellectually disabled, but that's irrelevant. The point is, I don't think the evidence can lead any reasonable person to say there is no way that he's intellectually disabled. I don't think it can lead a reasonable judge to say there's not sufficient reason to look into this question further when we have an IQ of 70.
Any
And
other questions, colleagues?
yeah, on that note, you know what I think. So thank you so much for your time.
Thank you very much. And thank you very much for both your arguments this morning. They were thorough, comprehensive, understandable. Appreciate it. And court will be in recess until 11:20.